Yeah. Mr. Reese, if it's easier for you to sit down,
I appreciate that. I should be just fine.
all right.
I
So
do appreciate the courtesy.
but any time that you need to just to sit down and elevate your legs, we are okay, and I'm sure council would agree as well,
Sure.
okay?
Thank you so much. I apologize for the sideshow. What's that, Judge?
That's a long time to be on 1 foot.
I should be okay. I apologize for the sideshow. There's
Okay,
no
if we
good.
didn't offer you the opportunity to sit, we would have to stand while you are.
I would never put the court through that.
All right.
I think we'll be all set here. Again, appreciate the courtesy. Attorney Ryan Reese, for the plaintiff appellant in this case, Jim Jamieson, I would like to reserve 5 minutes rebuttal time,
Very
please.
good, sir. Thank you.
2 United States Supreme Court cases govern the disposition of this entire case, the Lucas case and the Palazzolo case. If the proper standard of law is applied in the trial court, this becomes a very, very simple case. In the instance the law was not applied, which we submit was indeed the case at the trial level, as the court can tell by my initial brief, the issues become very, very muddied very, very quickly. And so my goal here today is simplify the issues and provide the court with what we contend is the appropriate law that gets to the resolution of this case the easiest way. In 1992, in the Lucas v. South Carolina Coastal Council case, the United States Supreme Court adopted a per se rule. And that rule was that when the owner of private property is called upon to sacrifice all economic uses of his property in the name of the public good or the common good, that is to leave his property economically idle, he has suffered a taking. And that's exactly what's happened in this case. The plaintiff owner has 40 platted residential lots on Fort Myers Beach. Despite those lots being located smack dab in the center of a residential neighborhood, the town elected to place a wetland future land use classification over the property. And on the face of this regulation, it's undisputed in the record that the owner can appreciate no economic use of his land. No economic improvements can be constructed. Over the course of 9 years, the plaintiff submitted 4 land use administrative applications seeking to vary from the wetlands land use regulation and appreciate some economic use on the property. It's important for the court to note that the grant of any one of those land use applications, we're not here today. Nevertheless, each one of those 4 was denied by the town's administrative body, or the town's legislative body, its council.
And as you know, they have argued you have not fully exhausted your remedies.
That's correct, Judge.
And you have responded. There was no point in going further. It was abundantly clear the position they were taking based on the previous 4 filings.
So your Honor brings up a really good point and used the phrase exhaustion of remedies. And exhaustion of remedies is essentially what the trial court imposed on the landowner in this case. You have to go through every step, every single remedy to try and be afforded the ability to appreciate a use, and that's just not the standard. And there's Supreme Court law that discusses the difference, the Palazzolo case, between exhaustion of remedies and ripeness per se. The ripeness doctrine requires that a landowner afford the unit of government the opportunity to render a final decision on how its regulations, the regulations at issue, the existing regulations, will be applied to the property in question.
And how do you respond, Ms. Reese, to their argument that they've told your client, here's how you could proceed, and then your client chose not to?
So a couple things. So we think we've reached the point of finality. Ripeness is encompassed by 2 prongs, finality and futility. To Your Honor's question, we've reached finality because we've submitted no fewer than 4 applications. We submitted an administrative interpretation in 2011, which, if granted, would have changed parts of the designation, the land use designation, on parts of the property to a non-wetland category. That application was denied. We applied for a comprehensive plan amendment, the very same amendment.
Some of the things you did were recommended by staff.
That's correct.
But denied by the council.
That's correct, Judge. That's correct.
But
And
you
so
keep-
we
you keep-
applied for, the staff recommended we apply for a comprehensive plan amendment. The same comprehensive plan amendment the trial court found was never applied for. So that's a factual discrepancy. But at any rate, applied for a plan amendment that was less intrusive on the density, on the development of the property than what is suggested by the town in its briefing. We applied to take the density off of the property, fulfill the town's desire that the property remain uneconomically vacant and shift that density to properties that I guess the town would contend would be more suitable for development. That was denied, albeit to your Honor's point that there was a favorable staff recommendation. We then applied for a minimum use determination. And that provision, and it's super complicated in the briefing, but is sort of a super variance. And so it's all other regulations being applied. The minimum use determination provision, it's called single-family residence provision in the comprehensive plan. It's called minimum use determination in the land development code. For our purposes, those two are the same thing. And what that provision does is it allows the town to avoid takings lawsuits. It allows the town to grant an economic use, the very bare minimum economic use of land, which is the construction of a single-family residence on each platted lot of record. And we applied for that in 2012. It was denied by council. We appealed. During the pendency of the appeal, we applied for the plan amendment. That was denied. We ripened the appeal. And the town, in what I would contend is in an avoidance of a takings lawsuit in 2014, granted us a minimum use determination, which says that the minimum that my client was eligible for a single-family residential minimum use on each platted lot of record. So it's somewhat surprising to me how they can argue that there's no right to a use of these platted lots when their council rendered a determination in 2014 that said the complete contrary. Why would they grant that? Why would they grant him an eligibility for a single-family residential minimum use if they didn't think he had any rights in the property?
Was it clear? We unfortunately are seeing more and more of these cases, and I've seen them in Lake County more and more. The question that I have is, when we're dealing about finality here, it's a very tricky topic because the Supreme Court has discussed that finality is not when the landowner feels as if it's, he or she or it is done. Finality occurs when I believe the zoning authority lacks discretion to give the relief that is being requested. Do we have that here, and what's the support for that argument?
Absolutely.
Because that's what's driven by Palazzolo.
And that's the case that I would cite to your honor that says, the same argument was raised by the government, by the state in Palazzolo, that the wetland regulations in that case, which are not unlike the wetland regulations in this case, were not clear and that he needed to make additional applications. And the United States Supreme Court rejected that argument and said the nature of the wetland regulations at issue is clear that the town lacks any discretion whatsoever to vary. No fill for a beach house, no fill for this, that, or the other is the exact language used in Palazzolo. No fill means you can place no residences on the property, and we have a very similar provision here.
Yeah, but the facts of this case cut against you to the extent that if there wasn't a way to exclude out the wetlands, then the single-family dwelling wouldn't have been carved out, which then leads to the conclusion that there is discretion left to be had here, and therefore it's not final, and thus we're not here yet.
So let me take a step back. The wetland regulations on their face there is the ability to still develop the property under that, just the wetland regulations themselves, because the owner can proceed through the single-family residence process and obtain a minimum use determination. And he did that here. The problem, and the town granted that acknowledgement. The problem was there's a provision in the code that is what I call internally inconsistent, that says that even properties with a valid entitlement to build a single-family residence on the property still can't build, still can't construct any improvements because it's labeled wetland on the comprehensive plan. And so we sought a variance from that provision, which was denied in 2015, which is what we consider as the ripening trigger to our case. So at that point, there was no additional administrative labor that we could have sought from the town under the existing wetlands land use classification that would have allowed us to appreciate any use on the property.
So no discretion left?
That's correct.
Thank you.
That's correct, Judge. So In the instance that the court were to find that there was a requirement, or what I call a categorical requirement for a comprehensive plan amendment, no Florida case and no national case is so held, but indeed that was the requirement that the trial court imposed upon us. Case just simply isn't ripe until you apply for a plan amendment. In which case, if the court were to buy that argument, we would still argue the second prong of ripeness, which is the futility component of it. And futility arises upon the filing of a meaningful application. Here we filed 4. And in which case, to Judge Badalamenti's point, there is no discretion left in the agency to do anything. And so we feel that we reached the point of futility based on our prior land use applications. And so this is really practical stuff that I want the court to understand. The town argues for a comprehensive plan amendment that would change the land use designation on all our portions of the property. That's the exact same relief that we applied for in the administrative interpretation in 2011. The fact that parts of the property could be developed with single-family residences on a plan amendment is the exact same relief that we would have been granted had the court acknowledged or had the town acknowledged our minimum use determination provision and let us put a single-family home on each lot. And the most egregious example is the fact that the comprehensive plan amendment suggested by the trial court is more intrusive in terms of overall build-out, construction, development than the request that we sought in 2013, 2014, which was to take the density off the property and put it somewhere else in other areas of the town. So we've contend that the requirement to apply for a comprehensive plan amendment is duplicative, repetitive, and arguably more intrusive than the administrative endeavors that we applied for. And the court will review the Palazzolo case. It says that landowners are not required to submit futile, needless applications, and the government simply cannot burden a landowner applicant with repetitive or unfair or unnecessary land use procedures in order to avoid the ripeness requirement. So I want to take a step back here because ripeness was one alternative finding that the trial court determined precluded our takings claim. The other claim, which Palazzolo is equally dispositive of, is this notion that the trial court found that because we purchased the property, my client undisputedly purchased the property while the wetland regulations were in place. He's dispositively or categorically precluded from prosecuting a takings claim. And so it's sort of the purchaser with notice argument. In other words, you bought the property subject to the wetlands regulations. You had no development rights in the property, allegedly, and so there's nothing that could have been taken from you. And so the purchaser with notice rule, admittedly, was indeed some of the prevailing law in this country in the 80s and 90s. And that issue specifically was visited by the Supreme Court in 2001 in Palazzolo. And if the court reads the state Rhode Island Supreme Court Palazzolo opinion, they're the exact same arguments that the town makes here and that the trial judge adopted in her order. For instance, bought with notice of the wetland regulation, it would be unfair to allow this purchaser to prosecute a takings case. Had no expectation that the property could be developed. Basically took the property as is. And the state of Rhode Island Supreme Court rendered that exact finding. And the opinion really mirrors the trial court's order in this case. The problem with that is that logic was flatly rejected by the United States Supreme Court on appeal to the nation's high court. And here's the quote from the case. The takings clause, in certain circumstances, allows a landowner to assert that a particular exercise of the government's regulatory power is so unreasonable or onerous as to compel compensation. Just as a prospective enactment, like a wetlands land use classification, can limit the value of land without affecting a taking, other enactments are unreasonable and do not become less so through the passage of time or title. Were we to accept the state's rule, which is the trial court's ruling herein, that you're just categorically barred from prosecuting a case because you bought with notice, the post-enactment transfer of title would absolve the state of its obligation to defend any action restricting land use no matter how extreme or unreasonable. A state would be allowed, in essence, to put an expiration date on the takings clause. And the court goes on to provide the real rule that it would be illogical and unfair to bar a takings claim because the post-enactment transfer of ownership where the steps taken to make the claim were not ripe by a previous owner. And that's exactly the case here. We took title of the property after the wetland regulation had been enacted, but the steps to ripen the case had not been taken by the prior owner. Palazzolo, I contend, is sort of the
You're about to go into your 5-minute rebuttal, so if you'd like to go forward, feel free, or if you'd
Sure.
like to reserve the rest.
I will reserve the rest of my time.
Thank you, sir. Good morning.
Good morning, Your Honors. May it please the Court, Hudson Gill on behalf of the town of Fort Myers Beach. And obviously, we feel that the trial court was correct in its rulings and the case should be affirmed. And ripeness is really the key issue in this case. And to step back a little bit, there's just some factual issues I want to make sure that the Court's clear on. The property at issue here is approximately 7-acre parcel that was purchased by the plaintiff. So that's what we're dealing with. We're dealing with the whole parcel of property. At the time it was purchased by the plaintiff in 2002, it had a wetlands designation on the future land use map.
But under Palazzolo, does any of this matter?
Without a doubt, it does matter.
Well, that decision seems to basically say purchaser's notice of existing regulations does not in fact bar him from later asserting the same regulations effect on an unconstitutional taking. This case seems to be right in the middle of your road.
Well, that is with respect to one finding of the trial court. That doesn't go to ripeness, Your Honor. That issue goes to whether a plaintiff can still state a claim when they purchase with notice. There were 2 rulings by the court with respect to count 1, which is the Lucas-style taking. The court said, number 1, you can't state that claim. It's meritless because you purchased subject to these restrictions. And number 2, the claim isn't ripe. Either one of those, if trial court was correct, requires affirmance for count 1. For counts 2 and 3, the court ruled on ripeness. So ripeness is really the key issue, and that has to come first. Ripeness is the threshold jurisdictional issue that a plaintiff bringing a taking claim has to satisfy to bring suit.
And in addressing ripeness, address the futility argument that
Yeah.
he's made.
Well, I think what's important, Your Honor, is to go through exactly what was asked for in each of those applications, what the code permitted the town to do, and what the town's response was. So, for example, I think I heard Mr. Reese say that the town council denied them all. Not accurate. Only one came before the town council. But we can go through each one of the town's responses because I think it's important to actually look at what was asked for, what the response was, and what was done. So the first thing that they're relying on is they sought what's called an administrative interpretation under our comp plan, which says that the entire parcel, that's what they were asking for, was declared, designated as a wetland based on clear factual error. That's the standard, clear factual error. What they relied on then is they submitted what they obtained a determination from the South Florida Water Management District that said, in fact, 60% of this property is wetland and only 25% is upland. And the town attorney's response is part of the record. It was attached to the complaint is one of the places. And he basically first lays out what the standard is, why and it's his decision, that's the person who does this administrative review, why he's not going to grant it, because basically, based on the South Florida Water Management District, it is mostly wetlands, and they're part of almost every lot. But then it lays out kind of a roadmap, what could be done to develop the property. Number 1, you could combine some of the lots so that there are no wetlands on there, because the wetlands sort of go through the property, the parcel. And then number 2, you could apply for a comp plan amendment to change the wetlands designation on those lots. So that's number 1. So with respect to whether that satisfies ripeness, again, it's all 40 lots is kind of what he's looking at. So it says, it's not an all or nothing approach. And have you applied for lesser uses? So then the next step they go is they do start this minimum use determination process. And the problem there is, at the time they sought this, the town's minimum use determination basically had a provision that said lots qualifying for a minimum use determination may not place a home, accessory structure, or driveway on any land designated wetlands. So he's asking for something that we can't grant, right? It's not going to get him what he wants per what our code says. And so that was really what the issue there was. Initially it was denied, and then it was stayed, while then he could seek this comp plan amendment. And again, that comp plan amendment, what he was asking to do was create what's called a transferable development rights sending overlay district, where he could then transfer all 40 of the development rights associated with those 40 lots to somewhere else on the property where there would be structures built. The issue with that in terms of ripeness is, the whole idea behind ripeness is letting the town or whatever agencies at issue tell you how far they'll let you go in terms of building on this specific piece of land. So the court can then make the determination of whether there's been a taking, right? I mean, if we say you can build 4 homes, well, that's certainly relevant to whether there's been a taking. So that's why we're allowed to exercise our discretion. That comp plan amendment wasn't trying to build anything on that property, so it doesn't really go to ripeness. It may have made him happy, it may have been a good solution, but it doesn't answer the ripeness question. So that gets denied. Then he goes through the mud, and again, he's asking for something that's not going to let him build on the lot because of what our code says. And then he does seek a variance of that provision. And this is sort of the last step, one of the last steps. And again, the town responds to that, and it wasn't denied. What the town says is, our code has a specific provision that says we can't grant use variances, meaning the use of this property. We're not allowed. It's prohibited from being granted. We can't even process that application. However, here's an application to apply to change the wetlands designation on some of the property. Here it is. We're giving it to you.
Well, it's abundantly clear, though, he's dealing with a hostile council.
Abundantly clear. I don't agree with that statement. I don't think.
Well, it just seems like that town council has no interest in seeing this land being anything other than wetlands, based on my read of this record. So help me, just abuse me of that notion.
So certainly the only thing that ever came before this council was that application to create the TDR Sending Overlay District. That was the only thing the council considered because that was the only thing that got to them. The only other piece of evidence that they cite to that says this is a hostile council is a resolution from 2002, a decade or more before these issues. It's not the same commissioners, right? The commission's a body of people. And all that says is we don't support anything that would impact the quality of those wetlands. Again, what this would be about, if you could carve out lots that weren't wetlands, then he could theoretically build, but you have to apply to have that change in order to do that. That was always the difficulty in developing this property since the 1980s, is that it was a wetlands designation. And just going on to continue with other things that the town does, after they file their notice of claim letter, the town attorney then provides a response to that, and it lays out in specific detail. This is attached to the complaint. It goes to the futility issue, so it's certainly admissible. The court was correct in doing that. And it lays out the precise steps that will have to be followed to develop this property and that the town will support them. It still has to go before the town council, but they've never been asked to rule on this. So I dispute that there's any record evidence that you have a hostile town council.
Part of this aspect, though, is that you're asking a landowner to try to figure out which thing is going to work. Over a course of 9 years, they tried 4 different ways. Now there's yet another way. And the argument is they haven't exhausted remedies. Well, they've probably exhausted their resources just trying to figure out which remedy the town council is finally going to say is okay. They have gone before the town council with staff recommendations to do something and have been totally shot down. I don't think it's reasonable to ask people to just keep doing this.
Well, Your Honor, if you look at what the standard for ripeness are and what needs to be done, we told him from the first moment he walked in the door and submitted that, here's what you need to do to develop the property. That's what we're required to do. The law says he's got to use the reasonable and necessary procedures in place. It also says it's not a meaningful application if you submit something that's going to be denied on its face. For example, the variance he asked for at the end, it could not be granted. We could not use, it was not within our discretion. What is in our discretion is to change the wetlands designation for some of the property. And that's what needs to be done, to let us exercise our discretion, say what we'll build. The only real evidence around this period of time is the October 2016 letter, which says we'll support 3 lots being developed. So 3 homes on this parcel is relevant to whether there's a taking. I mean, it's certainly a Lucas-style taking, which is, no economic benefit. If you look at the case like Palazzo, which Palazzo.
I have a hard time with it too.
Which you say it is. Look at the steps the owner did there. He filed multiple actual site plan applications, actual applications laying out, this is what I'm going to do over a course of decades, and reduced the size here. They've never done that. They've simply only asked here for 40 with respect to the Sending Overlay District, 40 with respect to the initial thing to change the wetlands designation for the whole parcel. He has to come back and actually try to do something we can grant for less than the full amount. And that's why it's not right. Because if we allow him to build 1 home, 2 homes, 3 homes, I mean, that's certainly relevant to whether there's been a taking. The court needs to have that information so it can perform its analysis of whether a taking has occurred.
So I'm curious, Mr., that means if they come back again and they seek that change in designation for the wetland on some of the properties, and if they get shot, to use Judge Morse's words, get shot down again, do they still have to keep on going?
I mean, I would submit under those facts that the case would then be ripe, because then they've actually used the procedure that will allow them to build on property. It was always the wetlands designation that was the issue. They've allowed this commission to exercise its discretion to grant it. If the town would then deny that, well, then I would submit to you that the case is much closer to being ripe there. So that's with respect to ripeness, Your Honor. And in terms of a hostile commission, if you look at like the Lost Tree case, they have actual statements in that case from the town council saying, we're not going to allow any development on this property at all. And then when the landowner there tried to challenge some of the regulations, this is the case that has to do with, it's 2 municipalities. You need a bridgehead to build on an island. One municipality says you can't do that, and the other one says, well, no homes on here without a bridgehead. The landowner challenged those regulations, and the towns fought him in court to support those regulations. And then you had comments from the town mayor. That is actual evidence to support futility. They don't have that here. All they argue here is because of what we've submitted, it hasn't been granted. Now, only one went before the commission. It wasn't actually a development application. But that's all they have here. They don't have anything else from this commission saying that they're hostile to development. In fact, you have the contrary. You have each time we respond, we tell him what he needs to do. He just simply doesn't do that. I mean, that's simply, that's the issue. So until we're provided the opportunity to exercise our discretion through what our code says we can do, not what Mr. Jamieson wants us to do, he's got to follow the proper procedures in the code, the case isn't ripe. So that deals with ripeness, which goes to 1, 2, and 3. The other issue with on appeal goes to count 1, and that's whether the purchaser with notice idea. In both the Lucas case and the Pozzalo case, in those cases, the specific facts, though, were a little bit different than what we have here. In the Lucas case, he purchases the lots, and then after he purchases them, the town or the relevant agency comes out with a prohibition that says no development after that. So he purchased after the fact. Here, Jamieson purchased after these regulations had been in place for almost 20 years. In Pozzalo case, it was owned through a corporation for decades. The corporation did some of the steps to develop the property. Through sort of a bankruptcy proceeding, the corporation ownership transfers to the owner, he was the only person in the corporation also, so it's not really a change. And the court says, no, under those circumstances, it doesn't bar him from making that claim. Here you have a person who purchased an arm's-length transaction. And if you look at some of the state cases, including a recent one, the Simon case from the first DCA, that basically says, yeah, if you don't have the rights to begin with, there's no taking, nothing has been taken. He did not have those rights to begin with, and so there's been no taking.
So my question is, I kind of asked the same question of your friend. 3 of the lots were permitted to be developed in this previously categorized as wetlands, pursuant to, was it an affirmative request for 3 lots, or was it an affirmative request for all the lots to be built on?
Well, there was never like an approval to do that. What the town said was, in response to their notice of claim letter that said, here's what we'll support, is 3 lots. There was no actual application made at that time, but that just goes more to give credence to what has been done before. This idea that this is what you need to do. You have to change this wetlands designation and combine some of the lots. He's never asked for that. So our job under ripeness is not for us to fill out the applications. It's the landowner that's got to go through the reasonable and necessary procedures. Now, he chose to use certain procedures that were available to him, but they're not the right procedures to ripen a taking claim.
Does the town have discretion to remove this designation and permit him to develop this land?
Yes, assuming he files an application to do it.
What kind of discretion? What does the application need to say? Walk me through it, as if I were the applicant walking in the front door.
Okay, well, if you look at...
It should be a simple process. Just spitball here with me.
Well, I mean, so if you look at the October 25th letter, it goes through that. And it's a land use, it's a comprehensive plan amendment, an application to change the wetlands designation for whatever lots you want to do. He would say, here they said lots 6, 7, and 8 because they're the ones that are most suitable for development because of where they are and where the wetlands are on the property. He would have to file that application to change that. That would then change the wetlands designation to presumably residential. And then you would also then have to change the, or no, actually, I've been thinking back. That, I believe that would then control, but the land development regulations are sort of competing, but once the comp plan changes, that's really the controlling document. then it's within his designation that can be developed, and he'd then have to file a typical building plan and site plan application to develop the
So
plan.
he would have to move to request redesignation under the comprehensive plan.
Yes, I mean, that is the step, the initial step that needs to be done, and always had to need to be done to develop this property.
And that has never been done for this property.
Correct. He's never filed that type of application. He did do an administrative interpretation initially, but that's a different process, a different standard.
What does that mean?
So it's just a process that's in the comp plan also that says if you believe your property's been designated wetlands or recreation, but wetlands here is what the issue was, based on clear factual error. So sometimes that happens. Say you have a lot and it's wetlands, but it's really not a wetland. You would apply for that and you would submit your evidence, and then they would say, okay, you know what, it is incorrect. This is truly not a wetland. The problem here is when he submitted that application, he included the determination from the South Florida Water Management District that showed most of this property is a wetland. Most of the whole parcel is a wetland, and he was talking about the whole parcel then. So that was the problem there. I mean, you have to follow the proper procedures to get this done.
So if he requested the redesignation under the comp plan of this property to be, the wetlands designation to be removed, and it is denied, it is ripe.
If it was for less than the entire property, I mean, I think if he comes in there and says, I want the whole parcel, all 6 acres, the wetlands designation changed, I think you have an issue that ripeness says it's not an all or nothing approach. You need to reduce the size of your proposed development. So I think he would need to...
But there's infinite number of reductions.
True, but he hasn't done any here.
I know, but I'm just trying to walk through it if I owned property. And it would seem to me then that you could, that the board can come back and say, well, it's not all or nothing, submit something less. He comes back and says, all right, minus 1 lot. And you say, no, that's not good. So go ahead, well, minus 1.5 lots. No, that's not good. And this could go on forever mathematically.
Well, I agree, and that's what the Palazzo case deals with. But in there, he's actually submitted applications to develop that reduce the size. He's never simply done that in this case. You have to look at specifically what he asked for.
I understand.
And
Thank you.
what our code says and what it provides. And
Thank you.
if your honors have no more further questions, then I will rely on my brief for the rest of the arguments.
Very good. Thank you, sir.
I'm going to sort of hobble over here to save some time. So I want to start with Judge Barlamente's point. Move to redesignate the property under the comprehensive plan to a classification that's not wetlands. We did that in 2010. We presented the town with a South Florida Water Management delineation. Council's alluded to that twice now. It said...
Help me out, Mr. Reed, because according to council, he said it was not done that way. You just simply, you proceeded under the provision that says this was an improper designation. It should not have been designated. It's a mistake. Is that correct?
So we proceeded under a comprehensive plan administrative interpretation provision. It is factually different than a comprehensive plan amendment. That provision was enacted to save landowners the time and money associated with a $50,000 to $100,000 comprehensive plan amendment. I mean, that's the point of the administrative interpretation process. It's in the record at 59 through 60. It says in there that this process was implemented to allow government to avoid takings lawsuits, to allow landowners to obtain uses, and to prevent situations where all economic use would be denied. And it was a cost-efficient process. Now, to Judge Barlamente's point, we presented them, with the town, with a wetland delineation that said 39% of the property is not even a wetland. That's at the state level. That's the DEP, South Florida Water Management District, that actually had the jurisdiction to be able to delineate wetlands. We presented that to the town and said, you have a factual inaccuracy here. We want 30% of the property to be changed from wetlands to a residential category. Denied. Okay, so why then, knowing that that's how they've treated our application, why would we go back and pay $50,000 to $100,000 for a comprehensive plan amendment that asks for the exact same relief?
How about to respond to council, like the letter that was attached to the operative complaint here?
Sure. So
that really designates and kind of walks
So there has never in this record, and ever that I'm aware of, been a formal, I think they called it an affirmative request that we could develop lots. The only representation in this record at all that says that this landowner could develop lots is from the town's advocate. It's in the briefing. There's never been anything where they have affirmatively said, come back to the drawing board and we'll give you, to your point, Judge, 30 lots, 20 lots, 10 lots, 5 lots, 1 lot. Never anything. So what happened was we sued under a categorical taking theory. We also sued under the alternate theory of a Burr-Harris claim. The Burr-Harris Act, it's Florida Statute 70.001, requires the landowner to make a claim pre-suit to the governmental entity. The governmental entity is then required to issue what's called a statement of allowable uses or a settlement offer. And that is essentially them offering something in avoidance of the lawsuit. It's a settlement offer. It's called a settlement offer in the statute. And in that settlement offer, for us to, the town offered to resolve the suit, and we could develop on 3 lots if we gave up all of our other rights in the other 47 lots. Okay, so I argued that that can't be used. Not only is it an improper settlement communication under 9408, that can't be used to demonstrate a lack of rightness. And I cite an example in my brief. Imagine at the 11th hour, you bring a claim for a total taking, and at the eve before trial, government tenders you a settlement offer and says, on your 400 acres, we're going to give you 1 lot. That defeats the Lucas claim, number 1. That also defeats rightness, because you as the landowner could always go back to the government entity and apply for that 1 lot on the 400 acres. There's not a Burr-Harris case, not a takings case out there at the state or national level that's held that you can use a settlement offer issued mandatory to statute to negate rightness or to negate futility. And the court should know, I attached that to my complaint. I had to attach that settlement offer to my complaint because under the Burr-Harris Act, I have to demonstrate that we've received the government's final statement of allowable uses. But it's
if you want to wrap it up,
sure.
You're
So
finished.
it's really important for the court to understand that that's not a use that's granted by right. Rightness looks at what you can do by right under the regulations then existing. A settlement offer doesn't, by its very nature, contradicts that. We're letting you do something that's in contradiction to right because in resolution of the suit. So we think, wrapping up, the record is undisputed. The court will note that I've asked to have this decision flipped. I think we've demonstrated all 3 prerequisites of a taking: rightness, lack of an economic use, and the absence of the nuisance exception, which I'll rely on my briefs for. We'd ask the court to hold the town accountable and declare liability for a taking in this case. Thank you very much for your time.